Yeah, slowly but surely, you know, I'm down to like 4 cases here. So yeah, so just run around there. I think I've started to get the grasp of how their logistics work. So, you know, got 212.
Okay. That makes sense.
All right. Ready? This is State of Wisconsin versus Darrell Brooks Jr., case 20 CF 2550. Appearances.
State appears by Jacob Core. Good morning, Your Honor.
Darrell Brooks appears by Attorney William Rakestraw and Attorney Robert Hampton. Good morning, Your Honor.
Good morning. The record should reflect that Mr. Brooks is actually appearing via Zoom from Dodge Correctional. We were on the calendar for a jury trial today. The court was contacted by the parties indicating that there was a resolution in this matter. And so we converted the jury trial date to a plea date. Mr. Core is in compliance with any required victim notification.
Yes, Judge.
And what is the plea agreement?
Judge, counts 1 and counts 2 are going to be dismissed outright. During the pendency of this case, we were unable to locate the essential witnesses as to those 2 counts. Given that we can only proceed on count 3, that is the count that he's going to be taking responsibility for. As to that felon in possession of a firearm, the state is going to make a recommendation of prison, leaving the amount up to the court.
Defense counsel, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Brooks, were you able to hear that?
I can hear the gist of it. It's kind of low over here on my end. I have it turned up, so okay. I can hear it, but not as good as I would like to. But
okay, are you able to hear me?
Yes, sir.
Okay, so what Mr. Core said was the plea agreement was that counts 1 and counts 2 are being dismissed outright because the state has been unable to maintain contact and cooperation with the necessary witnesses. So those 2 counts are being dismissed outright. The plea agreement is that you will be entering a plea of guilty to count 3, which is the charge of felon in possession of a firearm. And at sentencing, the state is going to recommend a term in the Wisconsin State Prison with the length and any details of that left up to the court, with you and your lawyers free to argue for what you believe is appropriate. Is that your understanding of the plea agreement, Mr. Brooks?
Yes, sir.
All right. The first thing I need to talk to you about, Mr. Brooks, is you're appearing today via Zoom from Dodge Correctional. As the defendant in a criminal case, you have the right to be physically present in the court when the judge accepts your plea and enters a judgment of conviction. You also have the right to waive or give up that right and agree to proceed via Zoom. So understanding, Mr. Brooks, that you do have the right to be physically present in the courtroom, are you willing to waive that right and agree to go forward today via Zoom?
Yes, I am.
Mr. Brooks, has anybody in the world threatened you in order to get you to tell me that?
No, Your Honor.
Mr. Brooks, have you used any drugs or alcohol today?
No.
And Mr. Brooks, has anybody promised you anything in order to get you to waive your right to be physically present in the courtroom?
No, Your Honor.
Have you had a chance to talk to Mr. Rakestraw and Mr. Hampton about this?
I talked to Attorney Rakestraw, not Attorney Hampton.
And was Mr. Rakestraw able to answer any questions you might have had about this?
Yes, he was, Your Honor.
All right. Mr. Rakestraw, have you talked to Mr. Brooks about his right to be physically present in the courtroom?
Yes, Your Honor.
And do you believe that his decision to waive that right is being made freely, voluntarily, and intelligently?
It is, Your Honor.
Mr. Brooks, I am going to accept your decision. I believe that you do understand your right to be physically present in the courtroom and that you have agreed to waive that right and go forward today via Zoom. Mr. Brooks, I am going to ask you to do a couple of things. One, if you have a problem hearing anything that's going on in court today, you need to raise your hand, do something to get my attention so that we can address that. Two, if you were physically present in the courtroom today and you had a question for your lawyers, you would be able to just lean over and ask them. But because you're appearing today via Zoom, that's not a possibility. So if you have a question that you need to ask your lawyers, again, you'll need to get my attention. I can open up a breakout room. They'll log in on a device and they can answer that question. Are you able to do that for me, Mr. Brooks?
Yes, sir, Your Honor.
Thank you. All right, Mr. Brooks, count 3 in the criminal complaint charges you with felon in possession of a firearm. That is a Class G felony. The maximum penalty for that is 10 years in prison and a $25,000 fine. That 10 years can be broken down as 5 years of upfront prison time, followed by 5 years of extended supervision. Again, because it's a felony offense, you will lose your right to possess a firearm. That is a lifetime ban, and you will lose your right to vote until your civil rights are restored. Mr. Brooks, understanding those are the maximum penalties, what is your plea to the charge of possession of a firearm by a felon? It's charged in count 3 of this information, which allegedly occurred on or about July 25th of 2020 at an address in the 4000 block of North 19th Street in the city and county of Milwaukee.
I plead guilty, Your Honor.
Mr. Brooks, your lawyers filed on your behalf a plea questionnaire and waiver of rights form, and it looks like you signed it electronically. Did you go over that form with one or both of your lawyers?
I went over it with Attorney Rakestraw.
And was Mr. Rakestraw able to explain everything on the form to you?
Yes, it was some things that I wasn't clear about, but he explained it as best he could.
Well, do you have questions now or anything that you feel like you don't understand about the information that's on that form?
Maybe 1 or 2 questions.
Do you know what, I guess, can you tell me what you have questions about?
I don't, it was maybe like a week and a half or so since we talked, so I can't remember exactly what it was. I just recall it was maybe something minute or minor. I just wanted some clarification on.
All right. So, and did they print out a copy of this form for you?
No, I have no copy of it.
Okay. So we'll start. The form tells me that you're 40 years old and you've completed 12 years of schooling. Is that correct?
I've received a GED, yes, Your Honor.
Okay. So it says that you do have a high school diploma, GED or HSCD. The form also says that you understand the English language and that you understand the charges to which you are pleading and that you are not currently receiving treatment for a mental disease or a mental illness or disorder, and that you have not had any alcohol, medication, or drugs within the last 24 hours. Are all of those things correct, Mr. Brooks?
Yes, sir, Your Honor.
And do you have any questions about those items?
No.
All right. Then the form goes on. It's got a portion that's labeled constitutional rights. And that part of the form states that you understand by entering that you're giving up the following constitutional rights. You're giving up your right to trial. You're giving up your right to remain silent and understand that your silence could not be used against you at trial, that you're giving up your right to testify and present evidence at trial, that you're giving up your right to use subpoenas to require witnesses to come to court and testify for you, that you're giving up your right to a jury trial where all 12 jurors would have to agree that I am either guilty or not guilty, and that you're giving up your right to confront people who testify against me and cross-examine them, and that you're giving up your right to make the state prove you guilty beyond a reasonable doubt. Do you have any questions about those items on the plea questionnaire and waiver of rights forms?
Say it again, Your Honor. I'm sorry. The last
Do you have
part.
any questions about those constitutional rights that you are waiving or giving up as a result of entering your guilty plea?
No, Your Honor. I'm sorry about that.
That's no, don't worry. All right. And then the next part of the form says that you understand the elements of the crime that you are pleading to. And for felon in possession of a firearm, there would be two elements. The state would have to prove that in Milwaukee County on that date in July of 2020, that you possessed a firearm. And they'd have to prove that prior to that date, you had been convicted of a felony offense, and that felony remains on your record and had not been reversed. So did you and Mr. Rakestraw discuss the elements of felon in possession of a firearm and how your conduct met those elements?
Yes, Your Honor.
And did you understand all that?
Yes.
The next part of the plea paperwork says that you understand the maximum penalties, which is that 10 years imprisonment or a $25,000 fine or both. Do you understand that?
Yes, Your Honor.
The next thing on the form talks about the fact that there is no mandatory minimum penalty for this offense, and also that there's no presumptive minimum for this offense. Do you understand both of those items?
I guess I do. I'm little.
All right.
With mandatory.
Let's go over that a little bit more then.
Okay. I'm sorry, Your Honor.
Sure. No, please. I appreciate you asking these questions. So for some offenses, and actually for this offense, there used to be what's called a mandatory minimum penalty. So that would, if there's a mandatory minimum penalty, that would basically take away the judge's discretion to sentence you to anything less than that mandatory minimum. But currently, for the offense of felon in possession of a firearm, there is no mandatory minimum penalty, which means the judge has complete discretion to sentence all the way from a fine or probation all the way up to the maximum penalty. But there's nothing that requires the judge to, there's nothing that limits that ability of the judge. There's no mandatory minimum sentence. Does that make sense to you, sir?
Yes, sir, Your Honor.
Okay. And then the same way there's no mandatory minimum, there's also no presumptive minimum penalty, meaning, again, there's not a presumption that the judge has to impose at least X as a sentence. So basically in the current state of the law for this charge is that the judge has complete sentencing discretion. Do you understand that, sir?
Yes, Your Honor.
All right. Then the next part of the plea agreement paperwork talks about understandings, and it tells you that the judge can impose a lesser sentence if the judge states appropriate reasons. It talks about the fact that if you're placed on probation and probation is revoked, if your sentence is withheld, the judge could sentence you to the maximum penalty. Or if a sentence is imposed and stayed, you'll be required to serve that sentence. Do you understand that?
Yes, Your Honor.
All right. Then the plea paperwork talks about the fact that if you're not a citizen of the United States, that your plea could result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that, sir?
Yes, Your Honor.
And then it talks about the fact that if you're convicted of a felony, you may not vote in any election until your civil rights are restored, and that it is unlawful for you to possess a firearm. Do you understand both of those things?
Yes, Your Honor.
All right. The next two things don't really apply to the offense that you're pleading to today, because it discusses a body armor restriction for a violent felony, and also the consequences of a serious child sex offense. So those don't really apply here today. the next part of the plea paperwork talks about read-in offenses, but today there is no read-in offense, so that doesn't apply. The next part of the plea agreement talks about restitution for read-in charges, and again, there are no read-in charges, and also that if a charge is read in, that you can't be prosecuted for that in the future. So none of that really applies today because the two charges that are being dismissed today are not being dismissed and read in, they're being dismissed outright. And then the last thing under understandings, it says that I understand that if the judge accepts my plea, the judge will find me guilty of the crime to which I am pleading based upon the facts in the criminal complaint and or the preliminary examination and or as stated in court. So do you understand that at the end of the hearing today, if I accept your guilty plea, I will find you guilty and we'll talk about a factual basis. Do you understand that, sir?
Yes, Your Honor.
All right. And then the next part of the plea paperwork is labeled voluntary plea, and it states that I have decided to enter this plea of my own free will. I have not been threatened or forced to enter this plea, and no promises have been made to me other than those contained in the plea agreement. Do you understand that, sir?
Yes, Your Honor.
And Mr. Brooks, has anybody threatened you in order to get you to accept this plea offer?
No, Your Honor.
Has anybody promised you anything other than the plea agreement that we talked about?
No, Your Honor.
All right. And the plea agreement, it says on here that the plea agreement is prison to the court, dismiss counts 1 and count 2. So, Mr. Brooks, that's all the information that's contained on the plea questionnaire and waiver of rights. Do you have any additional questions about anything that's on that plea questionnaire?
No, Your Honor.
So, Mr. Brooks, if I accept your plea today and we go to sentencing, do you understand that the way this will work is I will hear what the state has to say with regard to sentencing. I'll hear from your lawyers. And finally, Mr. Brooks, if you want to talk to me, I'll hear from you. But even if every single person recommends that I do the same thing, I don't have to follow anyone's recommendation. I can do what I think is the right thing to do, even if that means imposing the maximum sentence consecutive to any other sentence. Do you understand that, sir?
Yes, I do, Your Honor.
Prior to filing the plea paperwork, did you have an opportunity to discuss this plea with Mr. Rakestraw?
Yes, I did, Your Honor.
And are you making your decision to enter your guilty plea freely and voluntarily after having talked to Mr. Rakestraw and or Mr. Hampton about what your different choices or options were?
Yes, Your Honor.
During the time period that this case has been pending, have you had a chance to talk to Mr. Rakestraw and or Mr. Hampton or both about all the facts, about everything that happened on that day in July of 2020?
Yes, Your Honor.
So during your discussions with your lawyers, have you talked about possible defenses that you might have to this charge of felon in possession of a firearm?
Not in full, but it has been discussed.
Do you need more time to talk to them about the possible defenses you might have to the charge of felon in possession of a firearm?
I would maybe have just one question to them, but I don't think it would be anything that would alter what direction. Maybe just a little more clarity.
Okay, I'm going to ask Mr. Hampton or Mr. Rakestraw to step back into my jury room. They will log into my Zoom hearing. I'll open up a breakout room so the two of you can talk, okay? Or the three of you, I should say. I apologize.
Thank you, Your Honor.
You're welcome. And we'll just go off the record while we do that. I haven't seen Ms. Rockendorf.
She is out sick. I just got an email from her, so I'll cover her.
Okay.
plea.
All right. Because I did think I saw Mr. Yackman and Mr. Allen, but all right, we'll just wait. All right, Mr. Hampton has entered. I'm going to open up a breakout room. What'll happen, Mr. Brooks, is as soon as I open that and assign you to it, you'll go in automatically because that's the way that Department of Corrections sets up their Zoom hearing. So I don't know how you, I'm going to, do you know why you came out of that breakout room?
I do not, Your Honor.
All right. Let's try this. I'm going to move you to a different breakout room. This. And let's see if I can move you back to room 2. Yeah. No, I'll get a merit badge for that. Yeah. Oof. And I was off for a week. It's like,
And I don't know if you saw the email from Anik Ahmad regarding Velasquez. If we get back to him, I guess you got the numerical. Did you see that? About, it's not going to go. He just gave me a counteroffer. I hadn't talked to him. He gave me a counteroffer late on Friday, so I've not had a chance to reach out to the victim about that. Yeah, it's not going to.
We're good, Your Honor.
all right, we'll go back on the record. The record should reflect that I did open up a breakout room. Mr. Hampton and Mr. Rakestraw logged in on a device so that they could speak to Mr. Brooks. Mr. Brooks, were Mr. Hampton and Mr. Rakestraw able to answer the question that you had?
Yes, Your Honor.
All right. So have you had an opportunity to talk to them about both the possible defenses you might have to this charge, as well as talk to them about what happened on July 24th of 2020, so that they would know if there was an explanation for your possession of the firearm that would explain it in a way that would make it not a crime?
Yes, Your Honor.
And they were able to answer all your questions about that. Is that correct?
Yes, Your Honor.
Are you satisfied with Mr. Rakestraw and Mr. Hampton and the help that they have provided to you?
Yes, Your Honor.
Are you at all confused about anything that we are doing here this morning?
No, Your Honor.
And do you understand by entering your guilty plea that you are giving up your right to pursue those defenses, as well as any other explanations, which would be called mitigating circumstances? Do you understand that, sir?
Yes, Your Honor.
And do you have any questions that you want to ask me or your lawyer about what your rights are, the plea procedures we've gone through, any of the questions I have already asked you, or anything else that's happening here this morning?
No, Your Honor. I have no questions.
Brooks, are you pleading guilty to the charge of felon in possession of a firearm as charged in count 3, because you are in fact guilty of that offense?
Yes, I am, Your Honor.
Defense counsels, have you gone over the plea questionnaire and waiver of rights forms with Mr. Brooks?
Yes, Your Honor.
Have you gone over the elements of the offense with him?
Yes, Your Honor.
Do you believe he understands those?
Yes, Your Honor.
Did you go over the maximum penalties?
Yes, Your Honor.
Do you believe he understands those?
Yes, Your Honor.
Have you gone over all possible defenses as well as mitigating circumstances?
We have, Your Honor.
And do you believe he understands those?
Yes, Your Honor.
Do you believe that Mr. Brooks understands all the rights that he is giving up by entering his guilty plea this morning?
Yes, Your Honor.
And do you believe that decision is being made freely, voluntarily, and intelligently?
Yes, Your Honor.
Does the state consent to the jury waiver?
Yes, Judge.
Mr. Brooks, I am going to accept your decision to enter your guilty plea. I am going to find that that decision has been made freely, voluntarily, and intelligently. Mr. Brooks, that's just a little bit of a fancier way of saying, I do think you understand what you're doing. I think you understand what you are charged with. I think you understand the maximum penalties. I think you understand your rights. And understanding all of those things, you have made a voluntary decision to give up your rights and enter your guilty plea. I make that decision based upon the information that's in the plea questionnaire and waiver of rights form. That tells me that you're 40 years old and you have completed 12 years of schooling, or you have a GED or HSED. With that age and that amount of schooling, you would clearly be able to understand all of the information that is contained in the plea questionnaire and waiver of rights forms. So that is important. I also make my decision based upon the answers to my questions today. You have been very, very good today at making sure you were clear. If you didn't understand something, you didn't hesitate to let me know that. So your answers to my questions have been clear. They have been direct. Everything about the way you look and the way you've acted today makes me believe that you do understand what you are doing. I also will note that we have had multiple court hearings on this matter, and at every court hearing, the way you have acted and the way you have carried yourself makes me completely comfortable that you completely understand what you are doing. And so I am going to accept your decision Let's talk about the factual basis. The criminal complaint talks about some things that happened on July 25th of 2020 in the 4000 block of North 19th Street in the city and county of Milwaukee. So it says that the police went to a residence at that location. You were located there. You were taken into custody. They located a Beretta 9mm handgun that was on an air mattress close to where you were seated. So that handgun would have been, if not, would have been in an area that over which you were exercising control. And so therefore you had possession of it. And prior to that date of July 25th of 2020, you had been convicted in Milwaukee County case 1999 CF 4470 of the felony offense of substantial battery. That conviction remained on your record and had not been reversed. So Mr. Brooks, do you agree that on that date at that location that you possessed and exercised control over that firearm, and that prior to that date you had been convicted of a felony offense?
Yes, Your Honor.
Mr. Brooks, I'm going to find that that's an adequate factual basis, and based upon your plea of guilty and that factual basis, I am going to find you guilty of the charge of possession of a firearm by a felon as charged in count 3. That's contrary to Wisconsin statute section 941.29 pren 1M pren A, 939.50 pren 3 pren G. Because I've accepted your plea and found you guilty, you are once again a convicted felon. That means you cannot possess a firearm. That's a lifetime ban. You cannot vote until your civil rights are restored. Based upon the information provided to the court by the state today, I will dismiss outright counts 1 and count 2 based upon the fact that the state was not and has not been able to proceed on those charges. Is it my understanding that the parties want to go to sentencing?
We can.
Yes, Your Honor.
Okay.
Thank you, Judge. Judge, the court is very familiar with this case. We were in a position to try the first 2 charges early on, but I don't want to get into that. Obviously, I don't want to preclude us if, in fact, we are able to pursue these charges in the future. Mr. Brooks did take responsibility today for the felon in possession of a firearm. The court has just gone over the factual basis that particular count is pretty straightforward. They were investigating the underlying shooting. They found Mr. Brooks at the residence. They found the gun very close proximity to Mr. Brooks. Mr. Brooks does obviously have a criminal history. He's got a 2010 strangulation from Wood County. He's got a 1999 battery from Milwaukee, a 1999 substantial battery from Milwaukee, a possession of controlled substance cocaine from 2000, a possession of controlled substance THC from 2002, a resisting or obstructing from 2012, a 2012 possession of THC and bail jumping. There's another open matter currently in Milwaukee County, and then the court is familiar with Mr. Brooks's convictions in 2022 in Waukesha County. Judge, based on the totality of the circumstances, the state feels that a prison sentence is appropriate and leaves that to the discretion of the court.
Thank you very much.
Yes, Your Honor. For my client, Darrell Brooks, I'm making a recommendation to the court of 218 days in the House of Correction, which would be a time served disposition. Your Honor, Mr. Brooks is 40 years old, lifelong resident of Milwaukee. He has obtained his GED. He is the father of 5 children. As the state said, Your Honor, you're very familiar with the going-ons about this case in particular. Your Honor, the issue when it came to trial about this were about the first 2 counts, which were dismissed. Mr. Brooks was cooperative with officers in regards to count 3. He admitted to having a firearm to the police. If it was just about the felon possession, this probably would have been taken care of a long time ago. Obviously, we deny any assertions that Mr. Brooks committed a shooting or shot at anyone or anything of that nature. So this was, and so he's here, he's accepted responsibility for the firearm, which he always was willing to do, Your Honor, and had made statements to police in regards to that firearm as well. Your Honor, We know Mr. Brooks is in prison for an extended amount of time. This was his first firearm case, at least to my knowledge. He's never had any other cases with the firearm. The firearm he stated to me he took from his 17-year-old son, but again, never shot that firearm at anyone, admitted to having it. I do not believe any extra prison time is necessary and is kind of moot at this point, given the sentence that he already has. So I believe a time served disposition, seeing as this is he's pleading to only the possession of a firearm, and it's his first time being charged with possession of a firearm. I do believe a time served disposition would be appropriate, Your Honor. And that's why, Your Honor, I am making a recommendation of 218 days in the House of Correction, which would be a time served disposition. I'm asking for no fine. I'd ask that you waive any costs due to indigency and the fact that Mr. Brooks is going to be incarcerated essentially for all of the foreseeable future. And Your Honor, he has 218 days of credit. Thank you.
Thank you. Mr. Brooks, is there anything you wanted to tell me today?
Yes, I do, Your Honor. First, I want to say it's been a long road to get to this point. It seems like I've been coming before you now forever for this matter. I just want to take responsibility for the mistake I made that day. As my attorney said, it wasn't a malicious mistake. It wasn't, I didn't possess a weapon for any malicious intent. That was not my goal in that matter. It was a stupid mistake. Definitely something that I knew better than to be doing. And, I'm just ready to move forward now. Obviously, Your Honor, you're familiar with the current situation that I'm in. I'm just ready to just move forward. I'm ready to tie up my loose ends, so to speak. Ironically, since this situation has happened, it's ironically served to make me and my children's bond a lot stronger. I guess for them seeing what the mistake that I made had caused me to have to deal with, it's actually made them not even want to partake in anything firearm based or anything criminally based themselves, just by seeing the strain that it's caused in my life. And that's something that I'm proud of, because I don't want my mistakes to rub off on them in any way. My son is now 20 years old now. He's going into the military himself. He's basically trying to get out of Milwaukee because he recognizes that it's very dangerous, and it's a lot going on in Milwaukee right now. He wants to better himself, and a lot of that was seeing from my mistakes and everything that I'm dealing with. So it's been rough. It's been stressful. It's caused a lot of grief. 3 years worth, and I'm finally ready to put this behind me and do the best that I can going forward in the future, Your Honor. That's all I wanted to say. I thank you for giving me the opportunity to speak. I've tried my best to carry myself before you and before your court with respect to you and to the court. I've tried my best to keep my composure and do what is asked of me, and I'm ready to put this behind me and go forward.
Thank you very much, Mr. Brooks. So when a court makes a decision on sentencing, there are 3 factors the court needs to look at. 1 would be the seriousness of the offense. 2 would be your character, and 3 would be the needs for protection of the public. And in looking at this offense, felons in possession of firearms is a serious offense. We talked about this a little bit during the discussion, the plea colloquy, but there used to be a 4-year mandatory minimum for this offense. So it's clearly something the legislature recognizes as serious. The public is very concerned about felons having guns. So the offense in and of itself is serious. When I look at the circumstances in which you are convicted of this, I will note that the charges from the day before were dismissed outright, so I'm not going to consider that. The day that you were arrested with this gun, you were cooperative. So I think that in the scope of felon in possession cases, this case falls to the middle or lower end of seriousness. When I look at your character, that's obviously an incredibly difficult thing for me or any other court to comment on. What happened in Waukesha is that happened, and you've gone through that process, and that can't be ignored. I appreciate what you just said about the relationship that you have with your children, because it's obvious, but I'll say it, your goal has to be to and it's an uphill battle, but to not make that define you. And certainly with your family and those who love you, you have the ability to do that. And beyond that, neither you nor I control how the general public views you. But so I am happy to hear what you've said about the relationship with your children and your attempts to show them and to guide them. You've accepted responsibility here. It's been a long time in coming to fruition, but I know that, to be frank, the case was in a resolution posture, to my recollection, going back to 2020 on this, and then those other events intervened, and we ended up where we ended up. And then I look at what are the needs for protection of the public. As I said before, the public is rightfully concerned about felons possessing firearms. But in this particular situation, I mean, we've danced around the elephant in the room. There's nothing that I am going to do that is going to materially impact your situation. To be frank, I mean, it's a matter of public record what sentences you are serving, based upon. To a certain extent, this is an academic exercise, but ultimately, you've pled guilty to a felony offense. There has to be some, and you've accepted responsibility. There has to be some consequence on the record for that. So balancing those things, what I believe is appropriate is this. I am going to sentence you to a term of 4 years in the Wisconsin State Prison System, broken down as 2 years of initial confinement, followed by 2 years of extended supervision. I'm entering that sentence because, as I stated, in the scheme of felon in possession cases, I do believe this falls into the moderate or lower end, but prison, I think, is usually appropriate for felon in possession cases. So I am going to impose that sentence. I will make that sentence concurrent to the sentence in 21 CF 1848, which is your Waukesha County case. Again, given the length of that sentence, it just doesn't seem to make any sense to try and it'd be meaningless to run this consecutive And so I am going to run it concurrent. I don't know how that affects the pretrial calculation in terms of credit. I know Mr. Rakestraw indicated you had 218 days of independent credit. I'll certainly give you those 218 days. As conditions of extended supervision I guess let me first of all talk about court costs. I'm going to assess against you the mandatory DNA surcharge. I'll waive all other non-mandatory court costs. The DNA surcharge is to be paid from your prison account at an amount determined reasonable by the department. Anything that is unpaid while you're in would be a condition of extended supervision. Anything that was unpaid on extended supervision would be converted to a civil judgment. I have not studied what if any conditions of extended supervision there were in case 21 CF 1848, but given the fact that that just drives everything here, I'm not going to add any additional conditions. I'll just indicate that if you're released on extended supervision, you should cooperate with any programming that is deemed appropriate by your supervising agent. As a convicted felon, you cannot possess a firearm. That is a lifetime ban, and you cannot vote until your civil rights are restored. Good luck to you, Mr. Brooks. Thank you for resolving your case. Mr. Rakestraw and Hampton, will you advise Mr. Brooks of his post-conviction rights?
Will do, Your Honor.
All right, thank you very much.
Thank you, Judge.
Good luck to you, sir.
Thank you, Your Honor.
Yeah, he still so everything's over. Okay, that's right.
Okay.
Yeah.
So, where's Matthew? He was on Zoom because we have Alan for Plea.